So, yesterday there was a Supreme Court judgment about the withdrawal of life sustaining care for Harish Rana. You would have probably seen it in the news. It would have said passive euthanasia, that the court has actually given permission for passive euthanasia. The case is a lot more complicated than that. And what it does is brings into focus end of life care in India and the laws around end of life care. And even though this is an uncomfortable subject, we don't like to normally talk about it or imagine being faced with that question about a loved one. Um, these are real things that we must understand better. The case was about Harish Rana. Harish Rana actually fell from a building down 4 floors and hurt himself, and it resulted in a permanent vegetative state over the last 12 years. And he's been receiving clinically assisted nutrition and hydration. So he's been fed and given water through a feeding tube for the last 12 years. Now, his parents have approached the Supreme Court and they asked that medical experts and the court determine, which is the law, determine whether or not that life sustaining treatment is really in his best interest. The Supreme Court has ruled in this case that the treatment could be withdrawn. And this actually brings into question end of life care and brings back this focus. Now, remember, active euthanasia remains illegal in India, but the withdrawal of life sustaining treatment is permitted if it's in the patient's best interest. To help us understand what has happened in this case clearly, I'm currently joined by Dhvani Mehta, who is part of the legal team representing Harish Rana and his family before the Supreme Court. Thank you so much for speaking with me, Ms. Mehta. Thank you for the work that you do. And especially in this case, if you would explain to us really simply what this case was about and why it is so important right now in the Indian landscape.
Sure. So if I had to summarize it only in a line, I would say that this case was primarily about deciding whether the care and the treatment that Harish was receiving, specifically in the form of that PEG tube, was appropriate or not. And if it was not appropriate, what the logical consequence of that should be. So it was a case about stopping medical treatment. And I don't want to muddy the waters by saying that it was a case about deciding whether Harish should die or not. In fact, the court was at great pains to clarify that we're not in that business here. We're not here to decide whether he should die. We're here to decide whether continuing this treatment would be appropriate or not. Now, obviously, it assumes a lot more significance because, yes, the consequence of this stopping this kind of treatment ultimately will be that Harish will pass away. And because it is a question of life and death, and it is considered so naturally of such significance, this case found its way ultimately to court. And of course, I can explain in detail why later on and what the legal framework was. But very simply, this is the question that was before the court.
So when you say whether or not this treatment, which was basically receiving food and hydration through a tube, was appropriate or not, what do we mean by appropriate? Explain appropriate to me.
And maybe I should again expand on that and say that it's not just a question of whether it was appropriate, but whether it was in his best interests. And by this, I mean, I think I should start at the beginning by saying that every time a doctor decides whether or not to offer medical treatment to a patient, they must make a clinical determination of whether it would be appropriate to offer that kind of intervention or not. And by that, I mean, it could mean very simple things like, if it's a drug, it could be deciding whether that patient is allergic to that drug, knowing about the side effects that drug might cause. But also in more complex conditions and in more advanced diseases, it's also a question about deciding what is the therapeutic benefit that this kind of treatment will confer and what is the consequent harm that it will also add if you provide this treatment. And so there is always a judgment that a doctor makes about whether it is appropriate to provide this kind of treatment or not. For example, for lots of much older patients, who may be suffering from advanced chronic progressive diseases. They may be in their 80s, they may be frail. If they Doctors may decide that it's not appropriate to offer cardiopulmonary resuscitation, CPR, to them if they suffer a heart attack. So there is always a determination made at the doctor's end. Then if the patient has decision making capacity, there's always a question of obtaining the informed consent of that patient. So usually you ask that patient, look, this is what I am offering you. These are the benefits. These are the cons. Do you understand the information I've given you? Do you understand the risks? And if the patient agrees, then the treatment is provided. If the patient refuses, the treatment is not provided. Now, the complexity in this case arose because the patient doesn't have decision making capacity. And so, when there is no decision making capacity, then it becomes even more important for the doctor to act in the best interests of the patient. And it may be that at the initial stages, when Harish first had his fall and was found himself to be in this condition, it would be the natural and the right thing for doctors to recommend that he be given a tracheostomy, he be provided feeding through a PEG tube. Everything in that instance would be in favor of the preservation of life, doing whatever is possible to see that Harish makes a full recovery. And again, there are clinical guidelines that govern for how long this kind of treatment should be provided, how long you should wait to decide before it is irreversible or incurable. But after that point, once you have made the assessment that yes, now his condition is irreversible, there is now no hope of recovery. Now the only function that this treatment in the form of that PEG tube is doing is to prolong his existence in this condition. Then there is a determination to be made whether it continues to be in his best interests to provide it. And clinically, the determination is that it's going to do nothing other than keep him alive. But the non-clinical aspect of it is, what does this mean for the person that Harish was, for what his family members understand as his preferences and wishes, generally from the perspective of dignity, what would be in his best interests? And taking all those factors together, you reach a decision whether to continue that or not.
There was unfortunately in the media a confusion of terminology or nomenclature yesterday. When the judgment came out, all of the stories carried, including my own, and I accept my mistake here, we carried a term called passive euthanasia, which I understand now was a mislabeling of what we're talking about. So, could you explain to us where the error was, and also how is this decision different from, say, a DNR or do not resuscitate decision that is made in a hospital where someone is, where family decides that, okay, we will not do CPR if this person codes. How are these two things different? And is passive euthanasia at all applies in this in any way? And how have we gotten that wrong?
Sure. No, I mean, I think it's a very honest, I mean, it's not even a mistake. The court itself has been using this term for a while, so it was first set out in the Aruna Shanbag case, and then it was continued in 2018 when the Supreme Court passed its judgment in common cause, where it was considering all these questions in the abstract, and it was laying down the foundational legal principles of this. I mean, the distinction arises because of wanting to distinguish this from active euthanasia. And active euthanasia is, of course, the administration of, let's say, a lethal injection that brings about somebody's death. It is an intentional act. It may be conducted with with benevolent intentions, of course, and there are countries in the world where it is legalized. But at the end of the day, it is a positive, intentional act that brings in an external element that actually ends up causing that person's death. And the court wanted to distinguish the questions that came up before it, both in Aruna Shanbag as well as later on in 2018 and in Harish's case, from this intentional act. So they were at pains to clarify that what they are permitting in Harish's case is simply an authorized omission in some sense. And by authorized omission, I mean that not acting, so not continuing to provide this kind of treatment, which is sustaining Harish, but not providing that is authorized because it is in accordance with what the doctor's duty of care to their patient is. And the law sees this as a valid distinction. They see this intention to cause death and the absence in active euthanasia versus the absence of an intention to cause death in this case as a very valid one. I mean, to lay persons, it may seem like lawyering or semantic differences, but actually, it's very important to recognize that in this case, this is not about wanting Harish to die. It is simply about deciding the appropriateness of that treatment and then allowing whatever the underlying disease condition is, which in this case, is the injury he sustained and the vegetative state that he unfortunately finds himself in, to let it take its natural course. So that's the distinction between. That's why the court initially called it passive, although they recognize now in this judgment, and this is a very important step that the court has taken, to acknowledge that even calling it passive euthanasia once again brings it within the umbrella of euthanasia. And we actually want to remove this kind of case from that realm altogether.
So tell me now, in consequence of this judgment that we've had yesterday from the Supreme Court, what has changed in India when it comes to end of life care? Because, unfortunately, and I don't really know how many of our viewers are still listening, because these are not conversations people like to have unless they absolutely have to. Until you've reached that crossroad in your life, you want to avoid thinking about a loved one in this position. I myself have been in a similar position recently, and I understand the pain that families go through when you're faced with these challenges. So tell me, Ms. Mehta, what has changed now when it comes to the legality of end of life care in India? What can we interpret from this judgment?
Actually, nothing has changed with this judgment. It always was legal. So, and to just give you a sense of how the law develops in India, either it develops through statute or it develops through cases that are brought before the court and judgments that are given by court. And even in the absence of Indian cases, we've always had something called common law, which is law that we draw from UK principles, principles that we have adopted into our own legal system. And at common law, we've always had the fundamental principle that doctors owe a duty of care. They're not under a legal obligation to provide anything that is not in the best interests of their patient. And everyone retains the right at any time, if they have decision-making capacity, to refuse treatment. So these fundamental principles have always existed. Then they were clarified a little more in Aruna Shanbag, where it was recognized that, yes, you can withdraw life-sustaining treatment from a person who has lost decision-making capacity. And this was then confirmed by a bigger bench of the Supreme Court in 2018, a constitution bench, which said the same thing, but laid down some detailed guidelines for it. And now in this case, there is no new development of the law. The law has been clear that you can withhold or withdraw treatment. This case has just been the first case that has applied this to a particular fact situation after the first guidelines were laid down in 2018.
All right. Dhvani Mehta, thank you so much for speaking with me and helping us understand this better. And also thank you for the work that you do in this area with the organization that you have founded. I hope we can talk more and offer our audience more clarity in the future about cases like this. Thank you.
Absolutely. Would love to. Thanks for having me.